and welcome to Medizai, your one-stop resource for exam preparation. In this video, we'll answer 5 questions. Number 1. What's forensic medicine? Number 2. What's the role of a doctor in the justice system? Number 3. What's medical evidence? Number 4. What's the normal court procedure for a witness who gives testimony? Number 5. How should a doctor conduct themselves in the witness box? Before we start, please hit that subscribe button and like icon if you haven't done so already. There are many more good videos in the pipeline and you don't want to miss any one of them. Let's dig right in. What's forensic medicine? Forensic medicine is derived from the Latin root forensis, meaning an open court or public court. In modern usage, the word is an adjective meaning related to the courts or law. A similar meaning of the word forensic is the application of scientific knowledge to the investigation of crime. Thus, we commonly see expressions such as forensic expert, forensic evidence, forensic analysis, and of course, forensic medicine. Forensic medicine is a branch of medicine that deals with legal matters. A dictionary definition would be something like this: the discipline where medical knowledge is applied to investigating crime, particularly involving cases of injury and death. The specialty of forensic medicine has several offshoots itself. These include clinical forensic medicine, forensic pathology, forensic toxicology, forensic serology, forensic psychiatry, forensic entomology, forensic anthropology, and so forth. Of these, the 2 most important divisions are forensic pathology and clinical forensic medicine. Forensic pathology is chiefly concerned with the examination of a dead body to ascertain the cause and manner of death during a medico-legal investigation. Clinical forensic medicine, on the other hand, is concerned with the evaluation and interpretation of ill health and injuries in living individuals and thus aids in the administration of justice in cases involving living people. Let's move on to the second question now. What's the role of a doctor in the justice system? The doctor may be involved with the law in personal or professional capacities. As a person, he or she could be a party to a dispute, a victim of a crime, or even accused of wrongdoing, such that a lawsuit may have been brought against them. These instances are quite rare though, hopefully. More often, a doctor will be involved with the law in a professional capacity. That means the justice system may require a doctor to provide medical evidence. Before we move on, there are 2 or 3 terms that I must explain as they are expected to appear on the exam. The 3 terms that I want to explain are these: summons, subpoena, and evidence. A court may issue a document which commands the appearance of a person before a court. If a person is a party in that case which is going to be considered, then this document is usually called a summons. A summons thus is a notice served to a person informing them that a case is pending against them and asking them to appear before the court at a certain time and place. A subpoena is a similar document, but it's sent to someone who must testify as a witness in a particular case. Evidence, in its legal sense, refers to any materials or assertions of facts that may be submitted to a court of law as a means of ascertaining the truth of any alleged matter of fact under investigation. So it could be anything. Doctors are usually required to give medical evidence related to cases that involve their patients. That brings us to our third question. What is medical evidence? Medical evidence, like any other evidence, has two types: documentary evidence and oral evidence. Documentary evidence, as the word suggests, mainly refers to documents prepared by a doctor to be examined by the court. So they are usually forms of evidence in writing. There are three major types. 1. Medical certificate. 2. Medico-legal report. And 3. Dying declaration. What is a medical certificate? A medical certificate is a report that generally gives information about the patient's health status. 4 important areas must be covered: the birth of the patient, disease and its current status, the mental status of that patient, and if the patient is dead, an account of that. So these 4 areas are usually covered in a medical certificate. It's important to know that the medical certificate is a piece of document that has only matter-of-fact information. So it doesn't have any opinions. The doctor just describes what he has observed rather than giving any opinion about those observations. Usually, this document is furnished upon the request of a patient. Medico-legal report, on the other hand, is a different document. Usually, this report is prepared by a doctor once they've been asked by police or by any other law enforcement agency to give that evidence about the patient. In a medico-legal report, there are 2 parts. Number 1, the facts that have been observed about the patient, and those are not very different from the medical certificate, even though usually they are given in more detail. But there's a second part, and this second part is an opinion that is drawn by the doctor, and it's based on those facts that were observed. Now, this opinion could be different things, but usually it's related to, for example, criminal responsibility. So at the time of an offense, for instance, a patient may have been sick, and that may affect the level of criminal responsibility for that patient. So such an observation is formed into an opinion, and that is mentioned in a medico-legal report. The third item is dying declaration. It's a statement which is recorded from a person just before their death. In the statement, which can be recorded by the person in writing or verbally, usually describes facts related to their deaths, for example, the cause of death or the circumstances surrounding their death. If the death of a person is expected, it's important to notify law enforcement. If that's not possible, then the person may be dying in an emergency situation, then this statement has to be recorded by the doctor anyways. Sometimes the police may have to record a dying declaration. It's important to mention that the person had the mental capacity to make such a statement. In other words, if a patient is unable to hold a coherent and reasonable conversation, that may incapacitate them to make a reasonable dying declaration. A document similar to a dying declaration is a dying deposition. A dying deposition is not different from a dying declaration in that it's a statement made by a dying person and talks about the cause or the circumstances of their death. The main difference is that such a document or such a statement is made under oath, and there is usually a magistrate present. The person accused or his counsel is also present, and they can even cross-examine the person who's making that dying deposition. A dying deposition carries more weight in the court. Now, what is oral evidence? Oral evidence is provided by a witness who testifies in court. A doctor may be asked to appear in a court as a witness. There are two main types of witnesses: lay witnesses and expert witnesses. What is a lay witness? A lay witness is also called an ordinary or common witness. Another word is a fact witness. A lay witness just gives a direct first-hand knowledge of the matter that is being considered in the court. There is no training or qualification needed to become a lay witness. But we must keep in mind that a doctor may be a fact witness, and in that case we usually call it a professional witness. So they could be a fact witness, and even though a doctor is not a lay person, they are still acting as a fact witness, and they're not going to make any opinion based on their knowledge. They just give their observations as matter of fact, and that's how usually doctors are called into court to give evidence about their patients. The second type of witness is expert witness. An expert witness is someone who has certain knowledge, skills, and expertise that enable him or her to infer an opinion based on the facts in a case. A doctor can be an expert witness, and in this case, usually the person involved in the case is not their direct patient. So they're there just to give an expert opinion about the circumstances or the facts in that case. Now let's talk about the fourth question. What is the normal court procedure for a witness who gives testimony? Normally, when a witness gets a subpoena or a notice from the court to appear before the judge, they have to go there on the specific time and date, and once they are there, the first thing that is done during testimony is an oath. The witness takes an oath swearing by God only to speak the truth. The second step is called examination in chief. What that means is that the person or the party who brought the witness in support of their case would be allowed to ask questions so that the witness can give as much information as possible about that case. It's important to know that during this stage, the examination in chief stage, no leading questions are allowed. This is followed by the third stage, which is called cross-examination. In cross-examination, it's the accused or their counsel who puts questions before the witness. Here, the purpose is to identify inconsistencies, weaknesses, or a lack of credibility. An inexperienced doctor may find this stage very challenging. However, maintaining one's composure and professional demeanor is crucial. After the cross-examination, if the judge feels any questions need to be asked further, they can do that. Now, let's answer the last question. How should a doctor conduct themselves in the witness box? First things first, a doctor must show professional behavior in court. This means being punctual, being dressed formally, and standing rather than sitting in the witness box, unless asked to do so. Likewise, speaking clearly and at a comfortable speed and volume is important. Using simple and straightforward language is also crucial. An old saying that still applies to all doctors in the court is this: stand up, speak up, and shut up. It's also good to remember that your task as a doctor is not to save an innocent or convict a criminal. That is the judge's duty. Your role is to provide factual or expert information that will aid in the administration of justice. Thank you.